Good evening, class. Tonight's topic will be Title 6 of the Revised Corporation Code of the Philippines. We will be talking about meetings. Now, the source material for this lecture is Partnerships and Private Corporations by De Leon and De Leon Jr. as is applicable, and also Revised Corporation Code of the Philippines, a short introduction by Aquino and Aquino. So we will begin with meetings of stockholders or members. Later on, we will discuss meetings of directors or trustees. Now, for the meetings of stockholders or members, we will discuss sections 48, 49, 50, 51, and 53 of the revised code. Now, remember in section 48, it defines the two kinds of meetings that may be had by stockholders or members. So remember, the kinds of meetings are regular or special meetings. So the first question is, kailan ba nangyayari ang isang regular meeting? When does a special meeting happen? So for regular meetings, remember, they happen annually on a date fixed in the bylaws. So if a date is not fixed in the bylaws, remember, on any date after April 15 as determined by the Board of Directors or Trustees. How about special meetings? So for special meetings, it happens anytime as may be deemed necessary, or number 2, as provided in the bylaws. Now the next question is, saan naman? Where does the meeting happen? The meeting happens in case of a regular meeting of the stockholders or members in the principal office of the corporation. Paano kung hindi kasya dun sa principal office, yung napakaraming stockholders or members? If not practicable, remember, in the city or municipality where the principal office of the corporation is located. And also, in case of non-stock corporations, this is also subject to the provisions of Section 92. In Section 92, remember, for meetings of members in a non-stock corporation, it can be held even outside the city or municipality where the principal office of the corporation is located, provided it is within the territorial jurisdiction of the Philippines. The same rule applies in case of a special meeting. Again, it is held in the principal office of the corporation if it is not practicable in the city or municipality where the principal office of the corporation is located. This rule is again subject to the provisions of Section 92 in case of a non-stock corporations. Remember, non-stock corporations can hold their meetings even outside the city or the municipality where the principal office of the corporation is located, provided it's still within the territorial jurisdiction of the Philippines. How about the notice requirement? So remember, the notice requirement should be given, number 1, in case of regular meetings of stockholders or members within the period provided in the bylaws. So remember, in Title 5, we already stated that the bylaws can provide for the procedure in sending notices and also the periods in sending notices. However, if there is no such provision in the bylaws, remember, at least 21 days prior to the meeting. Now, in case of special meetings of stockholders or members, the notice must be sent within the period fixed in the bylaws. Now, if there is no such provision, again, at least 1 week prior to the meeting, prior to the special meeting. Now, the presiding officer in case of a regular meeting is the person designated in the bylaws. If none is designated, no person is designated, remember, the chairman is the presiding officer. Or if the chairman is absent, the president will preside. Again, this is without prejudice to the provisions of Section 49. This is in the latter part of Section 49, which I will discuss later on. For special meetings, again, the person designated in the bylaws will be the presiding officer. If no one is designated in the bylaws, it will be the chairman who will preside. In his absence, the president, again, subject to the provisions of Section 49. So in a nutshell, remember that those are the rules in case of stockholders or members meeting. However, of course, there are some qualifications or additional informations that should be additional information that should be given. So remember, class, that it is necessary to call meetings of stockholders or members. Why? Because again, stockholders or members can act only in meetings properly convened or assembled. Usually, as a general rule, the written assent or of majority of the shareholders or members without a meeting to a matter which requires action by them is not sufficient. So in short, kailangan daw magkaroon ng meeting ang mga stockholders or members, and the meeting must be properly convened and assembled. Now, the reason is for the protection of the stockholders or members, because if you give them notice to attend the meeting and they grab the opportunity to so attend, pwede silang makapag-discuss and they will be informed also. And again, they will have the opportunity to vote in the meeting. Now, remember also that there are exceptions to this rule when the Stockholders Act are valid, even if there is no meeting held. So, in Section 15, remember, in case of amendment of the Articles of Incorporation, pwedeng wala ng meeting yan, but it will require written assent of the stockholders representing at least 2/3 OCS, and in case of non-stock corporation, 2/3 of the members. So, written assent of 2/3 of the members. Here, in case of amendment under Section 15, meeting of the stockholders is not necessary. What else? Number 2, in case there is unanimous consent or agreement of the stockholders or members, even if it is not expressed in a formal meeting, all of them agreed to approve this action, even if there is no formal meeting. Obviously, this is a binding act on the corporation. What else? In cases provided for under Section 100, any action taken by the directors of a closed corporation without a meeting shall nevertheless be deemed valid unless otherwise provided in the bylaws. So remember, in Section 100, this will talk about closed corporation. So in closed corporations, remember, if there is consent by the other members of the board, written consent before or after any action is taken in an informal meeting, that is valid. Also, if the stockholders have actual or implied knowledge of the act of the board and they do not object, it is a valid action, even if the action was approved in an informal meeting. What else? Directors are accustomed to take informal action, that is also valid and binding kasi sanay naman sila sa ganung style na walang pa-meeting-meeting. Any corporate act approved in those kinds of informal meeting are valid and binding to the corporation. And the last one, even if in case all the directors have expressed or implied knowledge of an action and does not question it or does not make a prompt objection to the same in writing. So remember, in those cases mentioned in Section 100, even though there is meeting which is informally held in a closed corporation, valid and binding pa rin yung action taken by the directors in a closed corporation. What else? Number 4, obviously meetings in one-person corporations are not necessary. Bakit? Mag-isa na nga lang siya, magmi-meeting pa. So, as a rule, obviously, in case of one-person corporations, meetings are no longer necessary. Note also of the requisites for a valid meeting of the stockholders or members. So, number 1, it must be held at the proper place. Number 2, it must be held at the stated date and at the appointed time or at a reasonable time thereafter. Number 3, it must be called by the proper person. Number 4, there must be a previous notice. Number 5, there must also be a quorum. So please take note as well of the proper person to call the meeting. So the proper person to call the meeting is different from the presiding officer. The person who calls the meeting is the person who has the power, who can exercise the power to direct the secretary of the corporation to notify the stockholders or members of a meeting. Kumbaga, siya yung nagsasabi na, uy, mag-meeting tayo. Siya yung nagsasabi sa secretary na, uy talaga, no? Tawagin mo yung mga stockholders or members at tayo ay mag-meeting. So, yun ang proper person to call the meeting. Now, remember that the proper persons to call the meeting are: number 1, person or persons designated in the bylaws. Number 2, in the absence of a provision in the bylaws, the meeting may be called by a director or trustee or by an officer entrusted with the management of the corporation. What else? In case there is no person authorized to call the meeting or the person authorized unjustly refuses to call the meeting, the SEC, upon the petition of a stockholder or member on a showing of good cause, therefore, may issue an order directing the petitioning stockholder or member to call a meeting of the corporation. So here in number 3, there is no person authorized to call the meeting, or yung person who is actually authorized to call the meeting refuses to call yung meeting. So here, anong gagawin ng mga stockholders or members? Now, so the member, any stockholder or any member who is interested may go to the SEC and petition yung SEC to issue an order which will direct yung nagpetition na stockholder or member to call a meeting. So here, the meeting is called by the petitioning stockholder or member. Siya yung person authorized by the SEC to call yung meeting. Now, how will he call the meeting? By giving the proper notices as required by the code or by the bylaws of the corporation. In addition to this, remember, the petitioning stockholder or member shall preside at the meeting until at least a majority of the stockholders or members present have chosen from among themselves a presiding officer. So that is the last portion of section 49. Ito yung sinasabi kong i-discuss ko kanina nung nire-refer natin yung table. Now, what else? Please take note also, in cases of special meetings for removal of directors or trustees, it may be called by the secretary upon orders of the president, or if the president does not want to order or does not want to call the meeting. Remember, upon written demand of the stockholders representing or holding at least majority OCS or the members in case of non-stock corporation. So here in number 4, the meeting is called by the president by ordering the secretary to give notices, and or number 2, it may be called by the stockholders or members by written demand of majority votes of the OCS or majority of the members entitled to vote. Also, please take note of proper notices. So proper notices given to the stockholders or members should be, in case of regular meeting, should be 21 days prior to the said regular meeting, as I have already discussed a while ago, unless a different period is provided for in the bylaws. What else? For special meetings, at least 1 week before the special meeting, unless again a different period is provided for in the bylaws or regulation. Also, remember that written notice of meetings may be sent to all stockholders or members of record, may be mailed through the post office or sent personally, or because of the because of amendments to the code, it may now be sent by electronic mail or such other matter as the SEC shall allow under its guidelines. Please take note also, class, that notice of every meeting is required under section 50. So the rule is, the notice of meeting shall be sent through the means of communication provided in the bylaws, and the notice shall also state the time, place, and purpose of the meetings. So yung procedure for sending notices is usually governed in the bylaws. If there is no provision in the bylaws, remember, the manner prescribed under section 49 of the revised Corporation Code of the Philippines shall be followed. Please take note also of the requisites of notice of meeting. Number 1, it must be issued by the one who is authorized to issue it. Number 2, it must be in writing. Number 3, it must state the date, time, and place of the meeting unless otherwise provided for in the bylaws. Number 4, it must be sent at a certain time before the scheduled meeting as is fixed by law, unless a different period is required by the bylaws. Also, take note that it must state the agenda for the meeting or the business to be transacted during the said meeting. In addition to that, it must be accompanied by the following documents: a proxy form, in case yung stockholders want to attend by proxy, so they have to fill out the form, proxy form. What else? Number 2, when attendance, participation, and voting are allowed by remote communication or in absentia, the requirements and procedures to be followed when a stockholder or member elects such option. So anyway, ang kailangan yung tandaan dito, if yung attendance is allowed by remote communication or in absentia, ano ba yung procedures to follow? And ano ba yung gagawin ng mga stockholders or members who choose to attend via remote communication or in absentia? They have to follow yung mga procedures that are laid down in the notice of meeting. What else? Number 3, when the meeting is for the election of directors or trustees, the requirements and procedure for nomination and election should be provided for in the notice of meeting. Further, the notice must comply with any other requirements prescribed by law or the bylaws of the corporation. What else? The rules on waiver of notice to stockholders. We will go back to section 49. So remember, the rules on waiver is number 1, general waivers of notice in the articles of incorporation or in the bylaws are not valid. So tandaan nyo, yung mga general waivers, so nakalagay as a provision in the articles that all notices are waived. Hindi pwede yon. Nakalagay sa bylaws, all notices are waived. Bawal din yon. So the question is, pwede bang i-waive ang notice requirement even if general waivers are not allowed? Pwede. So notice of any meeting may be waived expressly or impliedly by any stockholder or member. Ang bawal lang is general waivers of notice as or a provision in the articles or the bylaws that waives yung notice requirement. Number 3 also, attendance at a meeting shall constitute a waiver of notice. Hindi ka nasendan ng notice pero nag-attend ka sa meeting, it is a waiver of the notice requirement. Except when nagpunta yung stockholder or members sa meeting precisely to object to the conduct of meeting. Bakit? Because for this stockholder or member, the meeting is not lawfully called or convened. So, if the precise purpose of the stockholder or the member is to question the validity of or the propriety of the meeting, remember, it does not constitute a waiver. Pero kung nagpunta lang siya doon, hindi naman siya nag-object, it is a waiver of the notice of meeting. What else? Failure to comply with the requisites for meeting under section 50. So, all proceedings had and any business transacted at any meeting shall be valid even if the meeting is improperly called or held, provided that the following 2 requisites are present. So, in short class, if you fail to comply with the requisites under section 50, valid pa rin yung meeting, but it is subject to 2 requisites. So, number 1, the first requisite is that the proceedings had and the business transacted are within the powers of the corporation, meaning they are they are not ultra vires. So, within the power, mas maganda intra vires. Now, what else? Number 2, remember, all stockholders or members of the corporation are present, or if they are not present, they are properly represented at the meeting. And none of them expressly states at the beginning of the meeting that the purpose of the attendance is to object to the transaction of the business because the meeting is improperly held. So, obviously, if the 2 requisites mentioned are not present, any action taken at the meeting shall not be valid. So, all proceedings had and any business transaction, if it does not have yung two requisites that I've already mentioned, are actions which are, any actions are not valid. So yun ang tandaan ninyo. What else? Matters to be presented by the board during regular meetings of stockholders or members. So this is a new provision, new portion of this provision. Nilagyan nila ito. So mahaba ito. Actually, number 1, bago pa lang mag-umpisa ang meeting ngayon, kailangan i-present nyo yung minutes ng most recent regular meeting. So in short, you will talk about the past meeting. So it will include a description of the voting and the voting tabulation process used in the previous meeting. Ang dami nito. Description of the opportunity given to the stockholders to ask questions and a record of the questions asked and answers given, matters discussed, resolutions reached. What else? Record of the voting results for each agenda item during the previous meeting. What else? A list of directors or trustees, officers, and stockholders or members who attended the meeting. What else? Such other items as the SEC may require. So, what else do you have to, what else are the matters that the corporation or the board has to present? So, members list for non-stock corporations and for stock corporations, material information for current stockholders and their voting rights. So, I wonder kung gaano katagal ang mga meeting na to kasi umpisa pa lang, ang dami-dami ng matters to be presented. What else? Number 3, detailed, descriptive, balanced, and comprehensible assessment of the corporation's performance, which information will include any material change in the corporation's business strategy or other affairs. So, meron pang assessment ng corporation. What else? Number 4, financial report for the preceding year, which shall include financial statements duly signed and certified in accordance with the code or as the rules the SEC may prescribe. So also, there must be a statement on the adequacy of the corporation's internal control or risk management systems and a statement of all external audit and non-audit fees. So, ang dami. Hindi pa nag-uumpisa. Ang dami nang nire-require. What else? Explanation for dividend policy and the fact of payment of dividends or reasons for non-payment thereof. Obviously applies only to stock corporation. Director or trustee profile. So, kikilalanin pa isa-isa yung mga director or trustees which will include their qualifications, relevant experience, etc., trainings, education, and also director or trustee attendance report. So, itong mga directors ninyo ng mga nakaraan, ano ba yung kanilang attendance? Did they attend the board meetings, etc.? Yung mga committee meetings, kailangan pa rin ilagay dyan. What else? Appraisals and performance reports for the board and criteria and procedure for assessment. So, meron pang assessment. Not only the corporation but also the board should be assessed as well. Compensation report. What else? Director disclosures on self-dealings and related party transactions. What else? Profiles of directors nominated or seeking election or re-election. So, this is all matters to be presented in a hearing. Iba pa yung talagang agenda nila sa meeting na yan. So, ang haba. What else? Please take note of agenda. So, in addition to the matters already enumerated under Section 49, pwede pa raw silang magdagdag ng other matter for inclusion in the agenda at any regular meeting of stockholders or members, and also propose also any agenda to be included in the holding of special meetings. Now, also in Section 49, postponement of meetings of stockholders or members. So, remember, in case of postponement, kailangan there is written notice, and the reason for the postponement shall be sent to all stockholders or members of record at least 2 weeks prior to the date of the meeting, unless there is a different period required in the bylaws or by regulation. Also, in Section 49, yung stock and transfer book at saka membership book must be closed at least 20 days before the regular meetings and 7 days before the scheduled special meeting. So, bakit? Kasi at least 20 days, kung sino lang yung nakalista sa membership books, yun lang ang allowed to vote during the meetings of the regular meeting of the members. In case naman of corporations, kung sino lang yung hindi delinquent na nakalagay sa stock and sino yung stockholders na hindi delinquent ang subscription na nakalagay sa stock and transfer book, sila lang ang allowed na mag-vote doon sa meeting ng stockholders, regular meeting ng stockholders. Yun nga, only stockholders or members of record can attend and vote at the stockholders or members meeting. So the manner of exercising the right to vote of stockholders or members, it may be in person, it may be through a proxy, which we will discuss later, or through remote communication or in absentia. What else? Quorum, Section 51. So remember, class, corporations can determine in their bylaws the required quorum in meetings of the stockholders or members. So for the transaction of business, in the absence of quorum, kailangan lang nilang mag-adjourn. So for quorum in case of stock corporations, it is based on the number of outstanding voting stock, meaning total shares of stock issued under subscription contracts, whether fully or partially paid, except yung mga treasury shares. So depende sa outstanding shares ang quorum. What else? Number 2, in case of non-stock quorum, non-stock corporations, majority of the members shall constitute a quorum unless otherwise provided for in the code or in the bylaws. So remember, the total number of registered members will be the basis for determining whether or not there is a quorum. Place of meeting, again, we will go back to Section 50. Principal office, if not practicable, city or municipality where the principal office of the corporation is located, unless provided for under Section 92. Yan. What else? Direct meetings of directors or trustees. In, again, a nutshell, we will discuss Sections 48, 52, and 53. Actually, this is predominantly covered by Section 52. 48 again talks about the kinds of meetings of directors or trustees, regular or special. 53 will talk about presiding officers for meetings of stockholders, members, directors, trustees. So again, for meetings of directors or trustees, kailan siya? On the date fixed in the bylaws, or if there is no date fixed in the bylaws, monthly. What else? In case of a special meeting at any time upon call of the president or as provided for in the bylaws. Saan naman? As fixed in the bylaws. But if there is no provision in the bylaws, anywhere, inside or outside of the Philippines. Now, also, the same rule applies in case of a special meeting. Notice requirement, within the period provided in the bylaws, but in no case should it be less than 2 days prior to the meeting. Now, in the absence of a provision in the bylaws, at least again 2 days prior to the scheduled meeting. Same rule applies when it comes to special meeting. Again, meetings, presiding officer, person designated in the bylaws. If none, the chairman, or in his absence, the president. Same rule applies to special corporations. Now, in addition to that, additional discussion, of course, there is a necessity for meeting of directors or trustees because, again, your board, as we already studied in Title 3, acts as a body. So, magiging binding lang yung action ng board if they act as a body. Now, how can they act as a body? They should act in a duly constituted meeting para maging binding yung corporate action ng board. Now, this is subject to exceptions, which I have already mentioned before. So, they must act as a board, not individually or separately. So, the requisites for a valid board meeting are, number 1, they should be assembled as a board, a body in a lawful meeting. Common sense ito, ulit-ulit ko nang sinasabi, Title 3 pa lang. What else? There is a required quorum. Number 2, decision of majority of the quorum, or in other cases, majority of the entire board. You will see in your book that there's an enumeration of the voting requirements for stockholders or members, and also directors or trustees, depending on the corporate action. What else? Meeting at the time, place, and manner provided in the bylaws. What else? The rules regarding quorum under Section 52 also. So, in case of the Board of Directors, the number required is the number fixed in the articles of majority of the number of directors or trustees as fixed in the articles of incorporation shall constitute a quorum. So remember, the number of directors or trustees, nakalagay yan sa articles of incorporation. So it is the incorporators who will determine how many directors or trustees are there. Now, unless the articles or the bylaws provides for a greater majority lang nung number of directors or trustees na nakalagay sa articles will constitute a quorum for the transaction of corporate business. For approval of corporate acts, so majority of quorum of the board. So remember, majority of quorum of the board for corporate acts, meaning to approve a contract with a third person, to buy property, etc. Kung ano lang, yung mga simpleng acts of administration approved by majority of the quorum of the board. Now, what else? In case of election of officers, again, majority of all the members of the board ang kailangan. So, number provided greater than majority, pwedeng gawin ito ng corporations because the revised code already gave the power to corporations to require a number greater than majority of the board members to constitute a quorum. Now, also take note na yung mga ibang mga nakikita yung mga corporate actions, especially sa Title 4, yung power to extend, shorten corporate term, power to increase, decrease capital stock. Nakikita nyo naman dun na ang required number of votes of stockholders is majority of the board. Pagka sinabing majority of the board, it is majority of the full board. Yan ang tandaan nyo. So, majority of the quorum, magkaiba sa majority of the full board. So, kung majority of the full board to extend or shorten corporate term, remember, parang yan din yung requirement in case of election of officers. So, anyway, also take note, proxy and constructive presence in meetings of the board, not allowed. Proxy actually is not allowed, but constructive presence as of now, meron na tayong bagong rules dyan. So, kailangan kasi ang mga mga members ng board should attend in person so that they can exercise personal judgment and discretion in running the affairs of the corporation. He cannot delegate yung powers niya or assign duty to another director, corporate officer, to any person. So in other words, he cannot appoint a proxy. So what else? In case of directors or trustees who cannot attend or vote physically at a board meeting, they can participate through remote communication such as video conferencing, teleconferencing, or other alternative modes of communication that will allow them reasonable opportunities to participate. Nakapag-participate kasi sila, that's why this is allowed. Nakapag-deliberate sila, nakapag-exercise sila ng discretion nila. Unlike if you appoint a proxy, yung proxy ang magde-decide for the director or trustee. Kasi hindi naman lahat ng matters pwedeng meron ng prepared vote yung or meron ng instruction as to how the the proxy will vote. Hindi naman kasi lahat ng bagay ma-anticipate. So, it may, sometimes yung discretion ng proxy kinakailangan, bawal yun sa board. Kailangan ang discretion lamang ng directors or trustee. So, anyway, in case of attendance to remote communication, please take note of SEC Memorandum Circular number 15 series of 2001, board meetings through teleconferencing or video conferencing, enacted November 11, 2001. So, kailangan director or trustees must choose and give notice that he will intend to resort to remote communication 5 days before the meeting, and all proceedings must be recorded and the recordings shall be stored by the corporate secretary. This is actually a long memorandum. Kinuha ko lang yung mga feeling ko importante. So, if you can, please also read this SEC memorandum. Notice again of every meeting of directors required. Bawal ang hindi magbigay ng meeting, but again yung notice of meeting can be waived expressly or impliedly. Yan. Yun nga, waiver of notice, meeting expressly or impliedly. Please take note also of recusal of a director or trustee under Section 52. So remember, any director or trustee who has potential interest in any related party transaction must recuse himself from voting on the approval of the said related party transaction. So, ang kailangan nyo lang tandaan, the director, if he has an interest in the transaction in which a corporation will enter into, so related sa kanya, he must abstain from voting doon sa approval ng party transaction na yan. Anyway, this is without prejudice to compliance with the requirements of Section 31 regarding self-dealing directors, trust and trustees. Please take note also in your book of the matters in which the law requires minimum number of votes. This is in your book, but I did not include this in this lecture kasi nga ang haba naman. So anyway, just peruse over yung scan yung mga items na yan. What you have to remember is that it defines kung ano yung mga instances when the law requires vote of the majority of the full board or vote of the majority of the quorum of the board. So, yun ang kailangan nyo tandaan. It also showcases when required ang majority OCS or majority of the members, or when required ang 2/3 votes ng OCS or 2/3 votes ng majority of the members. So, anyway, para hindi kayo masyadong mahirapan, bigyan ko kayo ng clue. In case of election of officers, in case of issuance of stock dividends, in case of entering into management contracts, and in case of fixing the issued price of no par value shares, dun lamang nire-require ang majority of the quorum of the board of directors or trustees as the case may be. For all others, they require, remember, majority of the full board. Ano yung mga acts na yon? To dispose of property, sell, lease, exchange, mortgage, pledge, etc., increase or decrease capital stock, incur, create, funded indebtedness, etc., etc. So, please just take a look at it sa inyong libro, yung kay De Leon class. So, what else? Presiding officer under Section 53, who shall preside at meetings. So remember, person designated in the bylaws will preside in the meeting. If there is no person designated in the bylaws, the chairman or the president shall preside at the meeting. What else? A stockholder also in a temporary capacity can preside in meetings. This has to do with yung there is no presiding officer and nagkaroon ng meeting, any stockholder or member who takes the floor may temporarily preside at the meeting pending the selection of yung kanilang talagang presiding officer. So usually class, yung presiding officer may be selected viva voce or by viva voce vote of the stockholders or members present. What else? Stockholders or members chosen by whom? Actually, it is the SEC who will choose. Usually, ang pinipili naman ng SEC is yung petitioning stockholder or member. So, this is under the Section 49, which I have discussed a while ago. When no person is authorized to call the meeting, petitioning stockholder or member authorized by the SEC will call the meeting and also preside thereat until a majority of the stockholders or members present have chosen one of their number as presiding officer. Manner of voting, so of stockholders or members. So remember, it may be direct voting and also it may be indirect voting through a representative. So what you have to remember in case of stock corporations, ang right to vote niya is again, like the right to elect, is again dependent on the number of shares. Yan. So, in case naman of non-stock corporations, remember the right to vote is kind of different. Kasi remember yung non-stock corporation, yung number of votes during an election is depending on the number of trustees to be elected. So if you are a member, there are 5 trustees to be elected. You have 5 votes. Yun ang manner of electing. But in case of manner of voting for a proposed corporate action, remember the vote is 1 member, 1 vote. So please take note also that in case of indirect voting, it may be by executors, administrator, receivers, or other legal representatives duly appointed by the court. What else? By means of a proxy. Or number 3, by means of a voting trust agreement. So, remember yung representative voting, i-discuss natin isa-isa. So, legal representative of stockholder or member under Section 54. So, sino ba yung legal representative? Any executor, administrator, receiver, or other legal representative duly appointed by the court. So, there must be an appointment by the court. So, they will vote the shares of yung person whom they represent. So, in case of executors or administrators, they will have a legal title to the stock of the deceased owner or their principal. Now, in case of secured creditors where stockholder shares are used as a security, remember here that the shares of the stockholder is used as collateral to secure a debt to the creditor. Now, the stockholder here is obviously the debtor, and obviously the stockholder is also the pledgor and mortgagor of the shares. Yung stockholder, sinangla niya yung shares niya sa iba. So, yung ibang tao na yan, creditor, mortgagee, or pledgee ang tawag sa kanya. So, in case of secured creditors, remember, the general rule is that the stockholder pa rin, who is also the grantor, who is also the debtor, the pledgor, or the mortgagor, he will have the right to attend and vote at meetings of the stockholder. Why? Sinangla lang naman kasi niya yung shares niya. Hindi naman niya transfer yung ownership. Sinangla niya, it means that it only secures payment of an obligation. Now, in case naman of creditor, pledges, mortgages, they can vote and attend at meetings only when expressly granted such right in writing by the stockholder. So, pwede naman na i-represent yung stockholder noong creditor, but remember, kailangan ng written authorization na sila ang mag-attend ng meeting and also will vote for the shares. So, the authorization required by the revised code is to be recorded on the appropriate corporate books by the stockholder, etc., etc. What else? Also, an officer or agent of a corporation owning shares. So, in this case, class, there is a corporation which owns shares in another corporation. So, what are the rules in this case? So, shares in the name of another corporation may be voted by an officer, agent, or proxy as the bylaws of such other corporation may prescribe, or in the absence of a provision in the bylaws, the board of directors may determine. They may be voted by the chairman or the board or the president, vice president, etc. But always remember, it is the corporation or the board who will appoint yung representative ng other corporation to this corporation wherein meron silang stocks. What else? Please take note also of the term proxy. Proxy is found in section 57 of the revised corporation code. Take note that it has 3 definitions. It may refer to the formal written authority given by the holder of the shares to another person. So in number 1, in the first definition, remember it will refer to the power given by one stockholder to another person. What else? Number 2, it is also used to apply to the person authorized. So it refers also to the person. So yung salitang proxy also refers to the written instrument which evidences the authority of the agent. So remember, tatlong definition. Proxy may refer to the power, proxy may refer to the instrument, and proxy may refer to the person who will act as a representative. So, requisites for validity of a proxy. So, remember, proxies must be in writing and signed and filed by the stockholder or member in any form authorized in the bylaws and received by the corporate secretary within a reasonable time before the scheduled meeting. What else? It shall be valid only for the meeting for which it was intended. Unless it is what? Unless it is a continuing proxy. A continuing proxy is valid not only for one meeting, kasi nga continuing siya, but the validity should not exceed 5 years at any one time. So, yun ang kailangan nating tandaan sa proxy. So, what else? Sino ba ang pwedeng maging proxy? So, any person can become a proxy. So, remember class that even if the proxy is disqualified, as long as the principal or the stockholder is qualified, pwede niyang i-appoint na proxy yung disqualified person. Ano bang disqualified person? Let us say, class, in a corporation. Yung isang stockholder, delinquent ang shares niya. Yung stockholder na may delinquent shares cannot vote in a meeting. Pero, what if this delinquent stockholder is appointed as proxy? Pwede siyang i-appoint as proxy, but he will not vote his own shares. He will vote the shares of the principal stockholder, which appointed him. So here, remember class, the proxy himself is disqualified to vote for his own shares, but he may act as a proxy for another stockholder who is qualified. Now, what if that principal stockholder is the one disqualified? Obviously, even if he appoints a proxy who is qualified, hindi pa rin pwedeng bumoto yung proxy na yan because the principal stockholder is disqualified. What else? Same person may act as proxy for one or several stockholders or members. And number 3, remember also that directors or trustees can become proxies in meetings of stockholders or members. But again, directors or trustees cannot appoint proxies to attend the board meeting. Yan. So, obviously, kasi anyone can become a proxy, it includes, remember, yung power, the opportunity for stockholders to solicit kung sino ang pwede nilang maging proxy. So, they can take a look at a list of existing or stockholders in the corporation. So, again, also, please remember the appointment of a proxy is a purely personal right. So, it cannot be denied to the stockholders. Yan. What else? Stockholder who authorizes a proxy or who appoints a proxy. Yung proxy ba ng stockholder, can he appoint another proxy? So in short, yung proxy ba pwedeng magkaroon ng proxy? As a rule, remember, hindi pwede. A designated proxy cannot further redesignate another under the same proxy. Now, obviously, a principal stockholder can appoint a proxy and also an alternate proxy. Yung alternate proxy will vote only when the primary proxy is not available to vote. So take note also of revocation of proxies. The rules are even if the proxies have irrevocable terms, they are always considered as revocable unless they are coupled with interest. Now, yung revocation ng proxies may be formal notice, orally, or by conduct. So, yung formal notice, madali na lang yan. There's a written notice given. Oral, madali rin, or by conduct. By actions. So, the stockholder will attend the meeting. Let us say, pumunta na yung proxy, tapos bigla nag-attend yung stockholder. Obviously, this is an implied revocation of the power of the proxy to represent yung stockholder. So, if both of them attend, the stockholder or the proxy, it is the stockholder who will vote during the meeting because there is already revocation of the power of the proxy. What else? Issuance of a subsequent proxy. So usually that is again a revocation of the prior proxy, and sale of shares again is implied revocation of a proxy. Also, please take note that in case of proxies in revocation, the last proxy given revokes all previous proxies. So, yung pinaka-last, yun ang valid proxy. Now, if it cannot be determined which one is last, and there is no sufficient time to verify kung ano ang valid proxy, the corporate secretary must refer the matter to the presiding officer whose decision will be binding to the stockholder, etc., etc. What else? Voting through remote communication or in absentia, also provided for in Section 57. What are the rules? There is voting in absentia when authorized in the bylaws or by a majority vote of the BOD. Yan. What else? Number 2, votes cast through remote communication or in absentia must be received before the corporation finishes the tally of votes. A stockholder or member who participate through remote communication or in absentia shall be deemed present for purposes of quorum. And lastly, corporation shall establish the appropriate requirements and procedures for voting through remote communication and in absentia, taking into account the company's scale, number of shares or members, structures, and other factors consistent with the right to vote. So, remember that this is proxy and also voting through remote communication or in absentia. But technically, remember, voting through remote communication or in absentia is not a kind of representative voting because here, malayo lang yung stockholder or member. Wala lang siya. Kumbaga, naka-zoom lang or kung ano man, whatever that is. But still, it is the stockholder who votes. In absentia naman, binili niya yung votes niya, etc. Meron siyang binigay na paper to represent his vote. Pwedeng ganun yun. So, kaya ko lang siya discuss here because it is included in Section 57. But technically, this is not a mode of representative voting. Personal pa rin ito. The next kind of representative voting is yung voting trust. So, remember class, yung voting trust or yung voting trust agreement is whereby one stockholder or a group of stockholder transfer their shares and authorize a trustee or trustees, pwede namang marami, and will give such trustee or trustees the right to vote and other rights pertaining to the shares for a period not exceeding 5 years at any one time. So in a voting trust agreement, obviously there is a voting trustor. Ito yung stockholder na magtitiwala sa iba at ibibigay yung kanyang shares. Para itong ibang taong to, he will be the one to vote for the shares. Now also, kung may voting trustor tayo, meron din tayong voting trustee. So the voting trustee is yung taong pinagkatiwalaan ng isang stockholder at siya yung tumanggap ng mga shares, nilipat sa pangalan niya, and remember class that siya yung boboto ng mga shares na yan. So remember, in a voting trust agreement, yung voting trustee will surrender yung kanyang shares of stock to the corporation, and the corporation will issue new ones in favor of the voting trustee. Also, obviously, itong voting trustor will enter into a voting trust agreement with the trustee. And the trustee, upon pagka-surrender ng shares sa kanya at sinurrender niya ito sa corporation, the voting trustee will issue a voting trust certificate na ibibigay niya dun sa trustor. So, anyway, yung mga trustors naman, yung voting trustee naman pala is, remember, siya yung magiging legal owner ng shares of stock. So, yung mga shares ililipat na sa pangalan niya. So, legal owner siya, although remember here that the beneficial owner is still the voting trustor. Please take note also nung sinabi ko kaninang voting trust certificate. So, yung voting trust certificate, ito yung ini-issue ng trustee sa trustor. Kumbaga parang acknowledgement receipt na, hello, natanggap ko yung mga certificates of stock mo, pinakancel ko at nilipat ko sa pangalan ko. Ito yung resibo na natanggap ko siya. So, yun ang tawag doon ay voting trust certificate. So, remember, it is executed by the voting trustee and delivered to the stockholder to show that in reality, yung voting trustor is the real owner of the shares of stock. So, what else? Remember class that yung voting trust certificates are also transferable in much the same way as stock certificate. So, subsequent purchaser of stock with full knowledge of the agreement takes it impressed with the voting trust agreement. So, yun ang kailangan yung tandaan. What else? Cancellation upon expiration of the voting trust agreement. Yung voting trust certificates will be cancelled as well. Also, yung certificates of stock in the name of the trustees will be cancelled as well, and will be, again, new certificates of stock will be issued to the name of the trustor. Now, the procedure for entering into voting trust agreement, number 1, a voting trust agreement will be first executed by the stockholder and the trustees or trustee, in case isa lang. Tapos, the voting trustee shall issue a voting trust certificate in favor of the stockholder. What else? The certificates of stock covered by the voting trust agreement shall be cancelled and new ones issued in the name of the trustee, stating that they are issued pursuant to the agreement. Remember also, sa books ng corporation, it shall be noted that the transfer in the name of the trustee or trustees is made pursuant to a voting trust agreement. So, doon sa stock and transfer book, ilalagay dyan na yung shares transfer sa trustee because there is a voting trust agreement. Also, mismo sa certificate of stock, you will see na it is issued pursuant to a voting trust agreement. What else? The VTA will be filed with the corporation and subject to examination by any stockholder, like any other corporate book or record. Unless it is expressly renewed, all rights granted in a voting trust agreement shall automatically expire at the end of the agreed period. Pagka nagkaroon na ng ending yung agreed period, remember, pagka dumating na yung agreed period, the voting trust certificates as well as the certificates of stock in the name of the trustee shall be deemed cancelled and new certificates of stock shall be reissued in the name of the original stockholders. So, powers or rights of voting trustee. So, the voting trustee shall have right to vote and other rights pertaining to the shares. Kasi nga, siya yung lumalabas na legal owner ng shares. So, sa books ng corporation, ang may-ari is yung voting trustee. The trustee may vote in person, by proxy, or in any manner authorized in the bylaws. What else? They may exercise the rights of inspection together with the voting trustor. What else? Trustee is the legal title holder of the shares. He is therefore qualified to become a director. Now, what about the voting trustor? Is he qualified to be a director? It depends. Kung nilipat niya lahat ng shares niya, obviously he's no longer qualified. But if he retains at least one share of stock in his name, syempre, pwede pa rin siyang maging isang director. What else? The limitations on voting trust agreement. No voting trust agreement shall be entered into for a period exceeding 5 years for every voting trust. In case of a voting trust requiring a longer period as a condition in a loan agreement. So, pwedeng mag-exceed ng 5 years ito. What else? Bawal din ang voting trust agreement for purposes of circumventing the laws against anti-competitive agreements, abuse of dominant position, anti-competitive mergers and acquisitions, violation of nationality and capital requirements, or in short class, if there is fraud. Bawal pasukan yung voting trust agreement na yan. What else? Agreement is in writing and notarized and specify the terms and condition thereof. Unlike in a proxy class, it is simply required to be in writing. Yung VTA nyo is required to be in writing and also notarized with the terms thereof or also indicated. A copy of the agreement is filed with the corporation and to the SEC. If not filed with the SEC, it is ineffective and unenforceable. What else? Subject to examination by any stockholder of the corporation as like any other book. And remember, all rights granted will automatically expire at the end of the agreed period, except class in case of a voting trust agreement required as a condition for a loan agreement, in which case it will continue until full payment of the loan. In case naman of joint ownership of stock under Section 55, ito yung mga shares owned by 2 or more persons. So, ito yung mga end shares. End shares. Medyo natakpan ko. So, in order to vote the same, the consent of all of the co-owners shall be necessary. Now, there are instances when the consent of all co-owners is not necessary. In case number 1, there is a proxy in favor of one of the co-owners. So, one or some of them. So, hindi na kailangan ng consent ng lahat kasi meron na silang representative yung proxy. What else? If the shares are owned in an N or capacity. So, in which case, any one of the joint owners can vote said shares or appoint a proxy, therefore. Also, please take note of treasury shares, voting rights of treasury shares. Dahil nga nasa treasury sila, surprise, they have no voting rights. So, walang voting rights ang treasury shares, wala rin silang dividend rights as long as they are in the treasury. So, ang mga treasury shares, yung mga shares na nasa treasury, ang pwede lang gawin sa kanila is to reissue them. Yan, for a valuable consideration. So, walang rights ang treasury shares until and unless they are issued. So, pagka na-reissue na sila, their voting rights and dividend rights will be restored. So, that's it for Title 6 of the Revised Corporation Code. Please stand by for Title 7.